The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. This is Tammy Weber. Welcome to Marshall, Parker, and Weber's webinar called What is Medicaid Spend Down? If you don't know who I am, you just saw the quick slide. Thank you, Stacy Zales. Our community outreach coordinator is sitting with me. She knows I don't like my picture too much, so we just moved right along. What I want to say is this is a 30-minute overview of this topic. So as you all probably can assume, we can't cover everything there is to know in 30 minutes. So I'm giving a little disclaimer that any planning that we do or information we're giving here today on this webinar is not one size fits all. Everybody's case is different. So here we go. If you apply for Medicaid or medical assistance for care in a nursing home or that level of care at home, which could be either the LIFE program, living independently for elders, or the waiver program, there's some rules. And those rules tell you how much you can keep in terms of resources. Simply put, if you have too many available resources, you've got to spend them somehow. So how does it work? Again, it reduces the allowable assets by purchasing things either that benefit the person applying for medical assistance or his or her spouse. So for example, most people think of the obvious, like paying off credit card debt or make an advance payment of real estate taxes or fixing up the home. I've had many of these in my history here, especially if the husband goes to the nursing home, the wife all of a sudden gets that great new kitchen she's always wanted. Or pre-funding irrevocable burial accounts. And we're also going to talk about a popular technique for reducing excess resources, which is purchasing a Medicaid compliant annuity. So next we're going to really talk about what are the income and resource limits. So the amount of resources that you can keep is tied to the gross income of the applicant applying for Medicaid. So if the gross income exceeds $2,250 per month, that applicant can keep $2,400 in available resources. And yes, if it's $2,251 per month, you exceed that amount. It's a black line rule. If your income is less, then you can keep up to $8,000 in available or allowable resources. And then when you're a married situation, so we're going to talk in a minute about Bob and Sue, they look at all of the available resources that both people have, they add them up, they divide by 2, and the spouse at home can keep half. But that half, there's a minimum and a maximum, and you can see those there on your screen. $24,720 is the minimum, and $123,600 is the maximum. So those are the math behind what we're going to talk about today. So let's talk about Bob and Sue. Contrary to the way we usually do here at Marshall, Parker, and Weber, we're going to send Sue to the nursing home today. Bob is going to be what we call the community spouse. So the first qualification, just as a refresher, is if Sue needs nursing home care or nursing home level of care at home under the waiver or the LIFE program, we first want to make sure that she meets the physical test. Just as a refresher, she's nursing facility clinically eligible, NFCE. So she needs help with her activities of daily living. So we're not going to talk about that anymore in this webinar. We're going to just look at resources. So here's her income, $825 gross Social Security, $125 gross bank pension, because she retired from the bank a long time ago. So she has $950 in total income. So it's very clear that her income is below the $2,250 maximum threshold. So she can keep $8,000 in available resources. How does it work for Bob? So let's look at both of their resources. They have a checking account, they have savings accounts, money market, and some savings bonds. Pretty simple for purposes of understanding these topics. So $100,000, and you're probably thinking that I made it easy math, and I did. So $100,000 total in available resources. And you will see, just as an aside, we haven't and are not addressing unavailable resources in this webinar. There are other webinars that we've done on all of the long-term care planning rules that talk about the unavailable assets, including, for example, the house and all of the things that could flow from that. So just for today, available resources only, $100,000 total. So as I said earlier, Bob gets to keep half. So 100 divided by 2 is 50,000. Sue keeps 8. So we have a total of $58,000 in resources that are available that both Bob and Sue can keep. And so we have $42,000 in excess that, in order for Sue to qualify for the Medicaid program, have to be spent or disposed of in some way. And this is where people go on spending sprees. Maybe Bob has a cool shop that he wants to set up, Stacy, and in his garage.
His man cave.
His man cave. Okay, the man cave in the basement. That is an option. Let's move on to the next slide. So there's going to be 3 choices we'll talk about. One is the Medicaid annuity. One is spending on the man cave or something else. And one is gifting, is another question we're often asked about. Let's start with the Medicaid annuity. So in this example, if you recall, we have the $42,000 in excess resources. So one of the choices would be to transfer that money to Bob's name alone, and Bob would purchase a Medicaid compliant annuity in the amount of $42,000. So if you're not familiar with an annuity, it's an insurance product, and a financial institution typically says, we'll return the principal to you either with interest or a fixed sum every month, and we'll give it to you in the future. Well, if it's an annuity for Medicaid qualification purposes, that amount of money comes back immediately in equal monthly payments. And typically, these Medicaid annuities are not the type of insurance product that you're going to make money on. It's very, very limited return. So the requirements, and there's quite a list as you can see, come from the state or the Department of Human Services, who manage whether or not Sue is eligible for Medicaid. And as you can imagine, taking $42,000 from the available to spend on Sue's care over to the unavailable column, they're going to have a few rules. So the first rule, and which is why you don't try this at home and you don't do this ahead of time, is the purchase of this Medicaid compliant annuity. It has to be irrevocable. Once you buy it, you're stuck with it. So Bob buys it. It's irrevocable. It's non-assignable. So Bob and Sue have 3 kids. Bob cannot decide, oh, I don't need this income. I have a really, really high pension. I'm going to give my income to my 3 children. No, that cannot work. Non-assignable stream of income. It pays to Bob in equal monthly installments. So each month he's going to get the same amount of money from this Medicaid compliance annuity. The period of time for the annuity cannot exceed the life expectancy of Bob. Well, where do you find that out? Well, Social Security has some charts that say how long an individual is going to live, and they're divided by an age of a female or an age of a male. So we simply look up that chart and see how long Bob will live. So say that chart says Bob will live, he has a 5-year life expectancy. This annuity has to pay out, so the $42,000 has to pay out to Bob for less than his 5-year life expectancy. And then the final requirement to make this annuity Medicaid compliant and take the $42,000 in excess available resources is that if Bob were to pass away while there's still some money left or payments from this annuity, the beneficiary of those payments has to be the Department of Human Services or the state government to the extent that they have paid for Sue's care. So if Bob lives and receives, in this case, all of the payments under the Medicaid annuity, the state does not get any money back. It's all used for Bob. Oh, then we come to spending. That's quite a nice car, Stacy. I'd like that. So Bob could say, oh, the heck with the man cave. I already did that with my man stash. I have another $42,000. I'm going to get a new car. You can do that. And a car is an unavailable resource. So Bob and Sue, Bob goes out and he upgrades their 1992 Subaru and buys a nice new Honda. That's fine. That's a way to get Sue financially eligible for Medicaid without any problem. The next one is gifting, and this can take a little bit of time, and everybody's circumstances are different. But honestly, I often hear, so we have extra money, I'm just going to give it to my kids. Well, as you know, when somebody applies for Medicaid, so in Sue's case, when Bob and Sue, or we do on Sue's behalf, apply for Medicaid for us, we have to show first that she's nursing facility clinically eligible, and then we have to show that her resources are down to below $8,000 and Bob's are down to the $50,000. And then the next question that's asked on the application is, did Bob or Sue give or transfer anything without receiving fair market value 5 years prior to the date that they apply for Medicaid for Sue? It's called the look back. And yes, it is still 5 years. It hasn't changed to 7. But sitting here today, if you're listening in the future, April of 2018, it is a 5-year look back. Often people are confused when they come in. They say, I protected my house, I gave it to my child, that doesn't count. They paid for it. And then I'll say, well, how much did they pay for it? They gave me $1. Oh, really? I don't know of any houses that are only worth $1. So that's fair market value. So the general rule is there's a gift or transfer without receiving fair market value, results in a period of ineligibility for Medicaid. The other question I often hear before we talk about the exceptions is, well, how are they going to know? What's the big deal? I deal in cash. They're not going to find that out. Well, yeah, the government, the County Assistance Office, which is the branch of DHS that's charged for monitoring and processing these Medicaid applications, has a right to look at 5-year priors of bank statements, not just things that are opened, things that have been closed. And as a requirement to get Medicaid, Sue or Sue's agent, Bob, has to agree that the county assistance office can run her social security number, her date of birth, find out anything she's ever received in terms of 1099s for investments, and if Sue or Sue's agent is signing the Medicaid application, they are signing it under penalty of law. So if they lie, there are repercussions in the future. So if there's cash payments and the county assistance office is looking at the statements and they see that twice a month there's $1,000 of cash that comes out, Bob and Sue are going to have an explanation for that. Because anything currently that's more than $500 in a calendar month does create a period of ineligibility. To explain that a bit further, I noted that Bob and Sue have 3 children. Bob and Sue can't write a check for $500 to each of their children without creating a period of ineligibility. It is $500 total. And also in that look back, they do, meaning the county assistance office, look at other gifts, churches, your charity of choice, etc. So let's talk about what doesn't create a period of ineligibility for gifts. One of the things that's somewhat misunderstood is to the spouse of the individual. So in Bob and Sue's case, if we transferred those $42,000 in excess resources, if they were Sue's and we gave them to Bob, that's fine. You can transfer assets of any kind from one spouse to the other without creating a period of ineligibility. The $500 total, as I said, you can transfer as well, but all of these have to be divulged to the county assistance office. If Bob and Sue had children that are under the age of 21, that's one exception to this gifting rule, or if children are blind or permanently and totally disabled. And again, this is just a general overview webinar, so what qualifies as totally disabled, there are regulations that explain that, and so we would want to look at that further with you if you thought that exception to the 5-year look back applied to you. Another possible exception under the current law is if one of Bob or Sue's children sold their house, moved in with Sue, and took care of Sue, sufficient that Sue's treating physician wrote a letter and said, but for Sue's child being there and caring for her the past 2 years or more, Sue would have had to have gone to a nursing facility. That's called the child caregiver gift of Sue's property. The next is if it's a gift made exclusively for a purpose other than to qualify for Medicaid. Now, most people will say, sure, I didn't know I was going to have Medicaid. Let's try that one. Well, honestly, sometimes this is hard. If, for example, the Sue and Bob were healthy, extremely healthy, and not an advanced age, and they've been for the past 35 years tithing to their church a certain amount every week or month or year, and there are records to show that, and Sue and Bob are both healthy, and this just unforeseen stroke happens to Sue, there's a good argument that they made those gifts to the church for a purpose other than to qualify for Medicaid. You don't always win that argument, but these days we've been successful in that regard. If Sue has had a diagnosis of something that would typically result in somebody being in a nursing facility for a period of time, for example, Alzheimer's disease, and she's had that diagnosis for 8 years and continued to tithe to the church or give $1,000 per child gifts every December for the holidays, there's a pretty good chance that the county assistance office is going to say, you should have known because of your diagnosis, and we're not going to allow those gifts to not have a consequence. The other exception to the gifting rule is, say, Bob and Sue gave some money to their child to get a down payment on a house because they really needed, depending on where you were, let's just say $25,000 for a down payment on a house. And they gave it to their son, and there wasn't a loan agreement or anything. And then the stroke happened to Sue. Probably you're not going to win that the $25,000 loan without any paperwork is a gift for another reason than to qualify for Medicaid. The county assistance office is going to say, no, you know what, you're going to be ineligible for $25,000 worth of gifts. But if their child can return that money to Bob and Sue, then it's not going to create a period of ineligibility. And the last really big exception, and I'm looking forward to, I don't see anybody typing yet, so get ready. If you have some questions, go type away, is if the period of ineligibility that would be imposed upon Sue would create an undue hardship in that she would have a problem and not be able to be cared for, etc. I had one of these probably about 5 or 6 years ago, and it's a hard case to make. It was a transfer, just so you can get an idea of what works in this regard, because we were successful to a certain extent, where a couple had a farm that they had worked their entire life, and 2 of their sons worked the farm with them. And they had gone to their general practice attorney and said, oh, you know, we want to give these acreage to our son, and here's how it's going to work. And while this couple was getting up in years, it is typical for farmers to essentially farm their land for as long as they physically can do so. So they had made a transfer based on an agreement that was in writing after the sons had paid a certain amount of money, not fair market value, and done some work for the farm. What happened was the father fell ill. Mother went to visit father at the hospital. She was doing fine health-wise, even though she was older. And while leaving the hospital, tripped on one of those lovely mats that they put down so that you don't trip when it's raining. And so clearly that wasn't expected. And as a result of that fall, had subsequent surgeries. The surgeries caused her to lose some of her cognitive ability, and she needed to go to a nursing facility. The transfer to the sons, the farmers, had happened within 5 years of the date of application for the Medicaid benefits for the mother. So we interviewed everybody. We talked to the accountants. We got affidavits. We had to have the sons sign an affidavit that said, I refuse to return this farm back to my parents. I earned it, etc. So we were successful under the undue hardship exception to the 5-year look back to getting mom on Medicaid without her having to private pay through a period of time because she did not have the money to private pay. So I must be doing a great job of explaining because there aren't any questions. We have one coming?
Yeah.
All right, we have one coming. So the question is, let me see, I gotta get my, okay, thank you, Stacy. The question is the $2,250 per month gross income limit to determine whether you can keep $8,000 or $2,400. Is that based only the applicant's spouse or on both spouses' income? Excellent question. It is based, in our example, only on Sue's income. So whether or not she can keep $8,000 or $2,400 in available resources is only based on her income. Bob could have $5,000 in income and Sue could still keep $8,000. Excellent question. Any other questions that we have going? Well, I'm waiting a couple of minutes here because we have a few minutes. I want to let you know the one thing that we didn't talk about today, which comes into play, is what if there was a gift made within those 5 years of Sue's application and the undue hardship exception doesn't apply and the disabled child doesn't apply and the caregiver doesn't apply and there's no money. Maybe Sue gave $10,000 to one of her children 2 years back and they spent it, so it can't be returned. What happens? And what are the risks involved? So the risks involved, if Sue has been admitted to a nursing facility, they cannot discharge her for lack of payment unless there's a safe discharge plan. So what would occur is the doctrine of filial responsibility will kick in and the nursing home could choose to sue 1, 2, or all 3 of Bob and Sue's children in order to pay for Sue's care costs. And that's the subject of another webinar that's saved at paelderlaw.com. At the top, you'll see our YouTube channel, the little red button, and you can press that and look at all of those. Well, thank you everybody for tuning in. We have one more coming in. So the question, and this is a little outside of the scope, but I can answer it, is how are IRAs and RMDs treated? So in Bob and Sue's example, this is what's available and what's not. So if Bob has a $200,000 IRA or 401k, since Bob is not the applicant for Medicaid, his IRA or 401k is in the unavailable column. And if Bob receives RMDs from that IRA, his income doesn't factor into how many resources Sue can keep, as we've already explained. But say Sue has a modest IRA left. It's $5,000, so her IRA would not have to be liquidated because it would be below the $8,000 in available resources that she could keep. So for purposes of how much she can keep, that's the answer. If she were receiving Medicaid at home, or for purposes of her income, They would look at that $5,000 IRA, look at what the RMD required is annually. They would divide that annual number by 12 and just say, so if it's $1,200 annually, it's a little high, but we're going to go for easy math, folks. So they would attribute $100 per month from that RMD to her income. So with her other income would be included to determine whether she went over the $2,250 gross income per month. The next question, and again, this looks like more a resource question. Do you look at joint accounts or accounts in Sue's, Sue's name only to determine available assets? So the rule for available assets for a married couple is, I call it his, mine, and ours. So if Bob and Sue have a joint account, or Bob even has his own accounts, money market, checking, savings, bonds, they are all considered available. If a corollary to your question is, does Sue or Bob have a joint account with a spouse or someone else? So say Sue and her daughter Sally have a $5,000 joint checking account, and it was sort of vacation money for the ladies. For purposes of Sue's resources that she could keep, if Sally could prove that she contributed money to that $5,000 joint account, then that proof of contribution wouldn't count. So in other words, if Sally says, Mom and I each put in the same amount every month, so half is hers and half is mine, and Sally could show those deposits, that only half of the $5,000 account would be considered available to pay for Sue's care. Great questions. Thank you for tuning in, and we wish you well.